Hello, Colorado real estate investors, landlords, Colorado tenants. Mark Cunningham at Grace Property Management. I want to share with you information about a bill that, depending on when you're watching this video, either is in effect now or is about to go into effect regarding the ability of tenant applicants. So tenants can apply to rent your property if you're a landlord, and you as a landlord must accept a tenant screening report provided by the tenant to you. Now, this has some details that we want to provide information on here to help both tenants and landlords in Colorado navigate this. Now, as a quick reminder, we are not attorneys. This is not legal advice. We're simply a property management company that has been around since 1978, and we do this to provide both our current landlord clients, our tenants, as well as landlords throughout Colorado and tenants throughout Colorado, information to ensure that you're behaving properly, following the laws that pertain to you for both tenancy and landlords in Colorado. So this is SB 23-1099. Senate Bill 23-1099 passed, has been signed by Governor Polis. The title of the bill is this: Concerning Tenant Screening Documentation for Residential Leases. The stated purpose of the bill is to save applicants money by not having to apply over and over and over again for a rental property. So as the legislature in Colorado was considering this bill, the legislature said that tenants had come to them and told them stories of these applicants having to pay thousands of dollars, that's what they said, thousands of dollars in application fees to landlords, only to get denied, and they were just spending so much money on the screening process that it was unfair. So the legislature attempted to rectify that situation and save applicants money by saying, gosh, well, rather than making the tenants apply over and over again, wouldn't it be great if they could just apply one time, they could get their report, and then they could provide that background report to property management companies as they apply. Now, as a property manager, at first thought this creates some potential problems, because if I'm accepting the background report directly from the tenant, how do I know it's legitimate? How do I know that that tenant hasn't gone in and created their own glowing background report on them, but they're really giving me accurate information? If they have terrible credit or if they have an eviction, can I expect them to be honest? And not to say tenants aren't honest, but gosh, it's ripe for fraud. Now, there are some specific aspects of the bill that'll hopefully mitigate that potential ability for people to bring false information in, but here's how it kind of works. Number one, it allows the applicant to provide landlords with what is called a portable tenant screening report, a PTSR, portable tenant screening report. So that's number one. It allows them to bring it. Now, this portable tenant screening report, the bill goes into great detail about what this is and what it is not. But it is defined as a consumer report prepared at the request of the applicant that includes a bunch of information about the applicant. So it's their request. They request this report from a credit screening bureau, and the report must include these things. It has to have their name, their contact information, their employment and income verification, their address, their rental and credit history, and a criminal history. So they go get it themselves from a credit bureau agency. It has to have those things in it. Now, it must be made available directly to the landlord, so to me as the property manager. So if someone's going to apply to me, to Grace Management, to rent one of our properties, that report has to be made available directly to us by the consumer reporting agency. So they can't walk into our office and just hand us a paper copy. They have to give us the ability to go to the consumer reporting agency with their permission and then pull the report from the consumer reporting agency that way. And the report can't be more than 30 days old. So there are some nuances there. Now, from a practical, logistical standpoint, this has not been figured out yet for our industry, because credit bureau reporting agencies right now, they're not doing this. They don't have to, and they're not allowing the tenant to give me permission for them to give me their report. I mean, just saying it sounds confusing. We can pull a report at our request, but this is saying, no, this isn't at our request. This would be at the request of the tenant provided to us. So logistically, no company that I'm aware of yet has built out this process on how it's supposed to work for the tenant to make the request or the applicant to make the request. And then what's the process to get that report through the bureau to us. The landlord cannot, this is another important aspect, landlords, we, Grace Management, we cannot charge any application fees to the tenant if they provide this report. So it costs us money when we pull our own report on an applicant, therefore the application fees. That's the idea of an application fee. So if a tenant applies to rent a property with us, they would pay us an application fee. Why? Because we have to pay that money to the credit bureau to get their reports, and we have to do internal screening as well, landlord check, we have to do a criminal check, and that costs time and money for us. So how do we offset that cost? We charge the applicant an application fee. Well, what this is saying is when they provide you the report, you cannot charge them an application fee. That's the whole purpose of the bill, is to save tenants money so they don't have to pay to apply. This also requires landlords to add new and very specific disclaimers and information to their advertising. So all of your advertising must, if you're a landlord, must contain new information stating that you abide by this, that you're willing to do this, you engage in this, and very, very detailed down to the size of the font that this disclaimer information has to have in place. Now, if you don't abide by this, penalties are $2,500 plus attorney fees for non-compliance. And then they even wrote in that criminal prosecution applies. This is not a civil matter. If you do not abide by this, the state attorney general in the bill has permission to prosecute you as a criminal offense. So this is a big deal. We don't want to get this wrong as landlords, as real estate investors in Colorado. Furthermore, it says this: if the applicant is denied, so if they apply and we deny that applicant, we must provide a copy of the background report to the applicant if we pulled it. So what that means is this: the tenant gives us their report, we still do have the ability legally to pull our own background report on that applicant. We can't charge them for that, but they can give us their report through the credit bureau. We can, if we question the validity of it, we can go pull our own report through our own bureau. We have to pay for that out of our pocket. The landlord has to pay for that now. Can't make the tenant pay for it. And if we deny based upon the information on the report we pulled, we have to provide the tenant with a copy of their report along with some additional information. Now that may sound straightforward. However, the idea of us providing a tenant with a copy of their own credit report is illegal under federal law. Federal law says that we, a third-party property management company, or you, a landlord, may not provide a background report or a credit report to anyone, not even the person on whom you pulled it. You can give them the information of the bureau, and they can go directly to the bureau, and that bureau must give them a copy of their report, but it's illegal under federal law for us to give it to anybody. This creates a problem because Colorado state law is in contradiction with federal law now. Colorado state law says, no, you landlord must give them a copy of their report. Federal law says you may not give them a copy of the report. What are property managers and landlords going to do in this situation? Well, the general consensus is we're going to follow state law over federal law in this case because this is such a big deal. And if we don't, as we just talked about, it's a $2,500 fine. Plus, you will be prosecuted as a criminal for not complying with this. It's a rather tricky thing to navigate. Now, this goes into effect August 7th, 2023. So depending on when you're watching this, this may already be in place. If you're a landlord and you don't use a property management company, this still applies to you. Now, there are a few carve-outs on things on the marketing and the advertising. You want to read the bill, go do that. As I said, this is not legal advice, but this applies to everybody. If you're using a property management company that's not Grace Management, make sure your company is doing this or else you could get sucked in to some of these penalties. If you're an owner-client of Grace Property Management, don't worry. We've got all this taken care of for you. That's what we do as a professional property management company. But if we can be a resource to you, assist you with the management of a property that you have, that you own, we're happy to be a resource. Jump on our website, rentgrace.com, or give us a call. Happy to be a resource if we can.